Assalamualaikum. I back to my lecturer, Miss Siti Hajar. First of all, I would like to introduce myself. My name is Nur Rabiatul Asyikin, 2018-263-226. I am from KBA 2435A. Today, my group member and me would like to talk about the court case study in Industrial Relation Court. The case is about minimum wage. The industrial relation is the relationship between labor and management, especially as a result from the composite attitude and approach to the management of industry affairs. It also can be described as relation in the industry, not only for the improvement of managing individuals, but also for the betterment of industry and the entire economy. The definition of industrial relation can be described how employer and management are connected to union agreement, either directly or implicitly. According to Bettel and others, industrial relations are the part of the management that concern the company staff. Based on the court case study that we have studied, there is several statutory law that has applied to settle the dispute among the employer and employee union. This case involved National Union of Hotel, Bar Restaurant Worker, Peninsular Malaysia, and Ramada Plaza Hotel Melaka. This case is about the complaint had lodged to industrial court claiming that respondent had breached the collective agreement.
Assalamualaikum warahmatullahi wabarakatuh. My name is Hafiza binti Yusoh. My matrix number is 2018682762 from class KBA 2435A. I will present summary case. Case that we choose is case between National Union of Hotel, Bar, Restaurant Workers, Peninsular Malaysia and Ramada Plaza Hotel Melaka, or the former names was Renaissance Melaka Hotel. In this case, National Union of Hotel, Bar, Restaurant Workers, Peninsular Malaysia is the complainant and Ramada Plaza Hotel is the respondent. The complainant had made a complaint to industrial court claiming that the respondent was breached one of the articles in its collective agreements, which is Article 12. In the collective agreement, Article 12A stated that the hotel shall retain 10% out of 100% service charge on all billed monthly. The remaining 90% service charge shall be fully distributed to all employees covered within the scope of this agreement as in Appendix B. Complainant mentioned that when the Minimum Wages Act 2012 was applied at the hotel, the respondent breached the collective agreement. On that time, the minimum wages for all employees in Peninsular Malaysia is 900 ringgit for every month, but respondent had increased the basic wages of employees that earn wage less than 900 ringgit per month by using their service charge. For complainant, it is counted as respondent had breached the collective agreement because, for them, minimum wages are basic wages that did not include any other charges, for example, service charge. However, respondent denied that Article 12 of the collective agreement had been breached. They claimed that they already add the service charge to the basic salary of the affected employee and state that the hotel employee who is said to be involved earns the same benefit as other employee, which is the employer pays the Employee Provident Fund (EPF) contribution, and the payment rate is determined based on the basic salary of 900 ringgit for overtime work. So the respondent argued that they were complied with Minimum Wages Act 2012. After cross-examination, the president and manager of Ramada Plaza Hotel Melaka admit the collective agreement had stated that service charge was an essential term and it was not part of the basic wages. He said that the 90% service charge that had been collected from customers already paid to the employee. Next, the Director of Finance also admit that the monies which was used to increase the employee's basic salary to the 900 ringgit was from the service charge. He contend that the respondent complied with Minimum Wage Act 2012. Act that had been used by industrial court in these cases are Section 56 subsection 2A Industrial Relation Act 1967 due to non-compliance proceeding. Second, Section 14 of Industrial Relation Act 1967, Next, Section 2 and Section 23 National Wages Consultative Council Act 2011 due to find the true meaning of minimum wages. Lastly, Trade Union Act 1959. The decision that has been made by the court is the respondent shall pay the service charge to the affected employees within 2 months from the date of award. to comply with Article 12 of the collective agreement. The court found that 10% of the service charge is not part of basic wages of the employees, so respondent cannot use it to increase employees' basic wages to comply with the Minimum Wage Act 2012.
There is several main sections that related to this case. The first one is Section 14. Section 14 of Industrial Relations Act 1967 is about collective agreement. According to Section 14, Subsection 1 of Industrial Relations Act 1967, a collective agreement shall be signed in writing by or on behalf of the parties to the agreement. A negotiated arrangement is a formal agreement between an employer or employers' union and a workers' union. The second section that related to this case is Section 56 of Industrial Relations Act 1967. Section 56 of Industrial Relations Act 1967 is about non-compliance with award or collective agreement. Section 56, subsection 1 state that any complaint that in the least term of any award or any collective agreement, the court can be deposited in writing with the court that has been taken into account by any trade union or person bound by such award or agreement. Besides, Section 56, subsection 2, subsection A of Industrial Relations Act 1967 is specified that upon receipt of a lawsuit, the court may issue an order ordering any party to comply with or cease to conduct any act in violation of the terms of the grant or collective agreement. The third one is National Wages Council Act 2011. National Wages Council Act 2011 is an act to establish a National Wages Consultative Council with a responsibility for carrying out survey on all its issue of minimum salaries and for the suggesting to the government that minimum wages be ordered in compliance with industry, form of work, and geographic regions. According to Section 2 of National Wages Council Act 2011, suggested that salaries had been same value as a Section 2 in this Act, unless the contact demand otherwise in the Employment Act 1955. The last one is Trade Union Act 1959. Workers in most sectors of the economy have been organized into union. A trade union is an association composed of affiliation. Affiliation is a group of organizations, and its membership primarily consists of employees. One of the key goals of trade union is to defend and uphold its member rights at work. Most unions are different from any employer.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. I'm Farif, Ikmal bin Ahmad Fauzi. So here I would like to present about the comparison part, and I will start with the wages under National Wages Council Act 2011. In this particular case, the main issue is regarding the collective agreement upon the basic wages. In 2012, government has gazetted the order of minimum wages for the first time. In the respective year, government gazetted the private sector workers in Peninsular Malaysia will receive a minimum salary of 900 ringgit a month. Meanwhile, workers in the states of Sabah and Sarawak will earn 800 ringgit. This is the first policy where it decided under the National Wages Consultative Council Act 2011. Then in 2020, the government has seen the need to raise the minimum wage rate. Government amended the minimum wages order to 2020, where it stated that the minimum wages will be caught up once again to RM1,200, but it only been enforcing for a selected town as outlined by the government. Then proceed with the collective agreement under Industrial Relations Act 1967. Basically, collective agreement come after two parties, which is the employer and employees, have a collective bargaining. The fact of this case explain that there are no collective bargaining process been held. The complainant claim the gazetted basic wages should be RM900, exclude the service charge. Meanwhile, the respondent stated otherwise. There is a contradictory statement between both parties, which means there is no agreement in the bargaining process. The third part is collective bargaining. It also amended under Industrial Relations Act 1967. According to the fact of this case, as stated before, no collective bargaining been held. In order to have the win-win situation for both parties, collective bargaining is necessary because it summarizes the agreement before determining in the collective agreement. And the last one is Trade Union Act 1959. This case has proven that the union performs its function well in defending the right of employees. Employees who do not join the union have the constraints in claiming the right if it denied by the employer. And absolutely no, the employer will not entertain with the claim. However, if the claim made jointly through union, employers have to comply and try to meet those demands. Part of that, based on the provision of the law, under Trade Union Act, the union must get the recognition from the employee first.
As the conclusion, the issue arising is whether service charge may be used to increase the basic wage of the employee for the respondent to comply with Minimum Wages Act 2012. Before the collective agreement exists, the employer and the employee union must carry out collective bargaining to obtain the agreement of all parties. Consequently, any person that breaches or does not comply with the terms of the article in the collective agreements shall be punished upon the signing of the collective agreement. In line with developments in the cost of living and so on, there are several amendments and enhancements in the Act. The Act to be referred to in the event of some issue is the most recent Act.
For the recommendation, from our point of view, the disputes occur due to the lack of communication before making an important decision. Both parties should have mutual understanding in certain issues. For instance, the hotel is experiencing a decline in profits, and at the same time, they need to comply with the Minimum Wages Order 2012. Thus, the employer has a constraint to comply with the order. Therefore, both parties should have a discussion on that particular issue and find a fair solution without neglecting the welfare of both parties. Moreover, the union need to convince employees who still consider the union is unimportant in defending their rights against employees. Besides, the employers also should not exploit the employees and take care of their welfare because they are an important asset to the company. That's all from me. Thank you.